Hi, my name's Aaron Lacey, and I'm the chair of the higher education practice at Thompson Coburn LLP. And you are listening to Title IX Determinations, which is part of our Thompson Coburn Title IX training series. So we welcome you back if you've already listened to some of the prior presentations. Thompson Coburn, for those who may not know, is a law firm in the Midwest, and we also have locations around the rest of the country. We're a pretty big firm, and I mentioned earlier we have a higher education practice. We have a number of attorneys who focus on working with colleges and universities and institutions of all types, providing them counsel on a range of matters, including those concerning discrimination law, so discrimination on the basis of sex or race or other protected classes. Today, well, let me start and say the purpose of this training series, as some of you may know, the U.S. Department of Education recently published its first new Title IX rule in about 4 decades. It becomes effective on August 14th, 2020. We're recording in July 2020, so amidst the COVID pandemic, you'll notice that my co-presenters and I are all in different offices or homes right now as we put this training series together. But we wanted to create some training so that institutions that are working towards compliance with this new rule could utilize it. We know with you all dealing with the pandemic and as well, it is particularly difficult right now to figure out how to provide training to all the folks who are going to be part of your Title IX process. And one of the things that this new rule has done is created a fairly elaborate and complex set of requirements for the management of formal complaints of Title IX sexual harassment on campus. So if you're an advisor or adjudicator, an appeals officer, or investigator, you're going to need training. And we wanted to try to make that available. It's free. We hope you'll watch it. And we hope you'll watch all the modules, at least, that would be of use to you. We'll also just make clear we're very happy for institutions of higher education to post this on their website. One of the sort of interesting wrinkles of the new rule is it actually requires schools to take all of the training they use for their different folks in those different positions and to post it on their external websites. So just to be clear, we're very happy for you to do that. That is one of the reasons we created this training. If you would like custom training to supplement what we're calling this foundational training series, of course, we'd be happy to talk with you about making that possible. The series consists of 6 modules, and in every training session at the beginning we show you this slide and the box that's highlighted orange here you see determinations. It tells you where you are in the training series. So hopefully if you're listening to this one you've already listened to the first 4, but it's okay if you haven't. You're also perfectly welcome to just jump in. So today we are talking again about determinations and formal Title IX formal complaints of Title IX sexual harassment. This is the syllabus for this particular session. So I'll start out, as I always do, with just a little bit of a recap and some context. And then our real core presenters today will get into key concepts, format and content, and other issues that concern the writing of determinations following an investigation and a hearing. Speaking of co-presenters, I'm joined today again, and if you previously listened to our investigations module, then you've already heard from Susan and Scott, 2 of my friends and colleagues at the firm. Susan is a longtime HR and employment attorney and has done many investigations and written many briefs and co-authored and ghostwritten, I suspect, many determinations over the years involving matters of discrimination based on sex. And Scott was the former Deputy General Counsel at Catholic University, was there for about a decade and has spent lots of time thinking about Title IX issues over the years as well. So as soon as I get through this little introductory section, I'll turn it over to Susan and Scott, and they can really get into the nuts and bolts of determinations with you. So speaking of the introductory section here, I like to always start with a brief discussion of the Title IX statute, just to remind you that the statute itself is pretty old, was put into place back in 1972, and broadly prohibits discrimination on the basis of sex at institutions of higher education. I make the point in every session, and I'll make it here again. Sometimes when people think about Title IX, they think of it fairly narrowly, either just in the context of equity in athletics, or these days, maybe just in the context of allegations of sexual harassment. But to be clear, the statute prohibits discrimination on the basis of sex in all programs and activities at an institution of higher education. So that's not just on the athletics field, that's in the classroom, that's in extracurricular services, all those different aspects. It's also important to note that it covers both students and employees And one of the real emphases of this particular rulemaking has been the idea that this Title IX process, and including the formal process for managing complaints of sexual harassment, also covers employees at the institution, not just students. And for many colleges and universities, that's a little bit of a change in the way that they've been thinking. The Title IX statute applies to all institutions that take federal funding, including those participating in the federal financial aid programs, which is most, and it's enforced by the Office of Civil Rights. So Congress created the statute. That's the way our laws work, right? And then they said to the U.S. Department of Education, now we've given you a statute that's pretty bare bones, and we want you to create a regulation that adds a lot to it and sort of explains to institutions more about what they are allowed to do and what they should not be doing. And the department did that way back in 1975. It issued a broad regulation under the Title IX statute. It includes some core concepts that most institutions, certainly those we hope that are listening in, already have in place. You have to have a Title IX coordinator. You have to have a non-discrimination statement. You need a process to manage complaints of sexual harassment or discrimination on the basis of sex, I should say. It is broader than that. And then finally, you have to take action to address sexual discrimination or discrimination on the basis of sex that's already occurred, and also to try to prevent it from occurring in the future. If you would like to see this new rule that was put out earlier this month, it's in the Federal Register, and you can click, if you have the actual slide deck, which should be near wherever these videos are posted, you can pull up this slide and there are active links, including this. You can click on that box and it'll take you to the page of the Federal Register. So you can actually look at the commentary, which is over 1,000 pages, even in the Federal Register format. And also you can look at the regulatory language, which is at the very end, by the way. If you go to this website, the new rules themselves are the very last part of the Federal Register entry. The last slide I want to hit on before turning it over to Susan and Scott is this graphic that you've seen. I won't say it's the last slide. There's a couple more, but an important one here is this graphic you've seen in every session. And it's our way of trying to demonstrate sort of the breadth of the Title IX statute, and then the focus in of the new rule on formal complaints of sexual harassment. So I mentioned earlier, the statute itself, very broadly, prohibits discrimination on the basis of sex. And institutions have to have a process, grievance procedures in place to manage any kind of complaint or allegation of sex discrimination. So if someone thought, you know, so-and-so was hired or promoted over me on the basis of sex, and that's discrimination, that would be a complaint under Title IX, and you need a process in place to manage that. But that's not sexual harassment, right? So the new rule is more tightly focused on what it calls Title IX sexual harassment. And in one of our earlier training sessions, Scott actually walked through this new definition of Title IX sexual harassment. I think that's in the very first session of the series, or the first module. But even more tightly within that, there's this concept of a formal complaint of Title IX sexual harassment. So if you have a complaint of sexual harassment, but it's not a formal complaint, there are some things that a school has to do. Again, we tackled that in the first module. But if an institution receives a formal complaint of Title IX sexual harassment, which is a specific kind of thing, then there's all this additional machinery that's put in place. And the new rule is primarily focused on that process for managing formal complaints. And that's what 4 or 5 of our 6 modules are focused on, is this formal complaint process. And if you're listening today and you're an advisor, an adjudicator, an investigator to be, or already serving in one of those roles, this is really the process where you're going to be most involved, is when a formal complaint is actually filed. A formal complaint, as I mentioned, is a pretty specific thing. So that means there was a document filed, a written document by either the complainant, the person who is alleged to have experienced the Title IX sexual harassment, or a Title IX coordinator, right, alleging sexual harassment and requesting that the institution investigate. So you could have sexual harassment without a formal complaint, and you would still have some things to do. We're really focused on the formal complaint, right? For the purposes of addressing a formal complaint, if you have one, the new rule lays out a pretty robust set of requirements that institutions have to satisfy. And here you'll see all those different requirements, right? So it goes through and you can see there's complaint dismissal, consolidation, notice of allegations, informal resolutions, hearings, determinations and appeals, all different kinds of things that you have to do. Today, we're actually focused, if you look down here, you'll see there's one on determinations, and it's that one category, and that's the category that we're going to talk about today in this session. So with that introduction being out of the way, I will gladly turn it over to Mr. Goldschmidt and Ms. Lawrence. Scott and Susan, please take it away.
Perfect. Thank you, Aaron. Thanks for that introduction. And again, happy to be with you and hopefully illuminate some of these concepts. So here we're going to start broadly with some key concepts about just the regulation and things that you should be aware of. If you've recently seen the previous modules that Aaron mentioned, these should be familiar with you. If not, we really go into detail about the meaning of each in the investigations and hearings modules. So I'd encourage you to go back and listen to those if you have specific questions about each one of these elements, but important to set the stage so that we're all on the same page and everyone's refreshed of what the concepts are. So the first that kind of permeates the entire regulation and kind of goes to the spirit of what the department's trying to do here is just treat the complainants and respondents equitably. So anything you do for complainants, any way you treat complainants, the same way, the same treatment and allocation and everything should be for respondents as well. Second, there's a requirement to objectively evaluate all relevant evidence. And so that means that includes inculpatory evidence, which shows or tends to show a respondent's responsibility for conduct, and exculpatory evidence, which shows or tends to show that the respondent's not responsible for the conduct. It's important to objectively evaluate that evidence and provide, and it's also a requirement that any credibility determinations made are not based on a person's status as a complainant, respondent, or witness. So you really just take everything as objectively as possible and kind of don't let any of these labels affect the way you treat and understand the parties involved. Next, just to understand and make clear that there's a presumption that's included and that everyone should be aware of, that the respondent is not responsible for the alleged conduct just because a complaint's been made. So just because a formal complaint's been filed, the respondent is not automatically responsible or tend to be responsible or judged as such. The respondent is only responsible after a determination is made at the end of the grievance process. Next, important to understand the standard of evidence. So schools have a choice between either the preponderance of the evidence standard and the clear and convincing standard. There's a lot of kind of thought that goes into which one the school might apply, including state law overlays and any other agreements you may have, which is discussed in another presentation. But once you determine the standard of evidence, make sure you understand that that's the lens that you're reviewing the evidence and making your determinations based off of. And last, don't require, allow, rely on, or otherwise use questions or evidence that constitute or seek disclosure of information protected under a privilege, a legally recognized privilege. So attorney-client privilege, doctor-patient, priest-penitent, those are potential privileges that an individual might enjoy, and unless that privilege has been affirmatively and knowingly waived by the individual holding that privilege, you should not seek to that information, rely on it. So it's important to understand that those can be appropriately made here in this process. Next, a little bit about the format and content. So here, as Aaron mentioned, we're talking about determinations. So investigations happened, the hearing process has happened, the board is, the adjudicators, decision makers, if there are more than one, are meeting and are about to kind of put down their final analysis of the facts and evidence into a document. So what do you do? So first thing to include is the allegations. So right up front, most likely, identify the allegations of sexual harassment in the document. Second is a procedural recitation. So after the allegations, explain what steps were taken in order to get to where you are. So from receipt of the formal complaint to the determination, what steps were taken. So any notifications, interviews, visits, site visits, methods used to gather evidence, hearings held, anything like that should be included. This is your chance to kind of work back from the regulations and make sure that you have identified all the required procedures that are mandated to institutions. But assuming you have complied and you have done all these procedural elements, you certainly want to get credit for it. So list it there and kind of lends credence to the fact that this is a thoughtful, deliberate, robust process that went through a lot of effort and procedural protections on your part. Next, the findings of fact. So what facts support the ultimate determination that's made, and citations to evidence and record only strengthens your case here. The conclusions, a lot to unpack here. So the conclusions regarding the application of the school's sexual misconduct policy to the facts. So this is the overall outcome here. Has to include a statement and rationale for the results as to each allegation, and that has to include a determination of responsibility in light of the standard of evidence, any disciplinary sanctions the school imposed on the respondent, if applicable, and whether the remedies are designed to restore or preserve equal access to the school's educational program to the complainant. So to the extent that restore or preserving access is important concept and part of the goal of Title IX to make sure that everyone has an equal access to education. The ways in which any disciplinary sanctions imposed, if at all, get to that goal that they restore or preserve equal access, that should be explained as well. And last, this might be right in your policy, but an explanation of the procedures and permissible bases to appeal. So Susan, over the past 2 slides, we just went over what was included in format and content required for determination. My question for you is how does knowing that at the outset inform the way that decision makers might approach questions to a hearing or the hearing itself or the determination letter?
Yeah, I think that's a great question, and certainly can be daunting for a novice adjudicator. So I think what's important is to look back to the complaint or complaints itself and allow those to really guide you in what the information is that you need to glean and what the elements of those claims include, whether it's looking back at the policy or whatever information was provided in the investigative report, and letting that form the script, so to speak, and checklist of the way in which you're going to approach the written determination and the hearing itself.
My next question is about the evidence that you would include in a written determination. So presumably at this point of the hearing, there's been some whittling down of evidence and relevant evidence, but presumably decision makers have a mountain of evidence that they are presented with, and not all of it they find relevant to the actual determination. So I'll start by just explaining the preamble to the rule. Notes that the department does not require the written determination to include all facts, all evidence, all contradictory facts, all exculpatory evidence, because in the department's mind, decision makers have an obligation already to review and objectively evaluate all relevant evidence. But Susan, from a practical perspective, how does a decision maker take this evidence, knowing that they don't have to include all of it, and kind of make a decision about what evidence should be included?
Yeah, and ultimately that is their role as the adjudicator to make those decisions. So they have to be guided by the investigative report and what evidence was included and relied upon during that. They also need to be making the credibility determinations that the investigator, for the most part, did not and should not have done so. Which is not to say that they do need to review everything or include everything in their written determination. They really just need to be guided by an objective, unbiased perspective and be mindful of the elements of the claim and only rely upon relevant evidence in making their determination.
Great. So moving right along to the logistics, and I think we'll talk about excluding evidence, excluding some facts and evidence a little bit later, but just in terms of the general logistics of how to distribute the determination. So the regulations require the schools to provide the determination to the parties simultaneously, and the determination becomes final either on the date in which the appeal would no longer be considered timely, So in your notice, you would inform them, according to your procedures, how long they had to file an appeal, and to the extent that they do not exercise that option within the amount of time that the determination will be final, or if an appeal is filed, the date on which the school provides the party with the written appeal determination.
And Scott, this is Aaron. As if you wouldn't know, uh, who do you think I'm in your past experience is really responsible? I'm curious if this is the Title IX coordinator that's issuing. Obviously, if the adjudicators are authoring the determination, would you expect the coordinator to actually distribute it to the parties? Would you expect counsel for the institution to assist with that process? Practically speaking, how, in your experience, would you typically expect that to play out?
Yeah, and I think this could depend on your school's process. But in my experience, it would be the authors of the determination. So it would be from the chair, the presiding officer of the decision-making body, or a staff member that assists that organization to actually send out the determinations. The coordinator role to I think to the best of their ability would kind of stay above operational details and kind of focus on making sure that the whole process is compliant. And as I mentioned here, so excluding facts and evidence, just a few quick questions. And Susan, I'll pose this one to you. In a hearing process, so you mentioned before in the key concepts that privileged information is something that should not be sought, but there's other aspects of evidence that could be introduced or inadvertently said or purposely said that the decision maker hears but is not able to consider and really should not have been said. So what happens realistically when a decision maker hears a party or witness inappropriately discuss things like privileged information, treatment records, or irrelevant information, and how would they go about that decision?
And this is something that happens with some frequency in all different types of forums, and including in a forum like this, where information comes out and you are either told after the fact, maybe by the advisor, that that information was privileged, and it's sort of the equivalent of them objecting to that information. And you then, as the decision maker, are called upon to not take it into account, even though you've heard it, right? So this is not an easy task to unhear something or forget something that you did hear. And yet that's exactly what you need to do. You may not consider any information that inadvertently or inappropriately comes out or is provided without the person knowingly waiving that right. It's not uncommon that someone is so embroiled in the testimony they're providing that they forget that that information was provided to them by their attorney or discussed with their physician or whatever else. So when that does occur, the decision maker may not consider that information. They should really, as a best practice, consider stating for the record that that information was inappropriately disclosed and will not be relied upon. And frankly, if they cannot do that, if they feel like it's just an impossibility for them to not rely upon inadvertently produced information, they should consider recusing themselves, because it really does delegitimize the entire process at that point.
Absolutely. Another tough situation for adjudicators is how to weigh facts. So a lot of time will have been spent in these hearings presenting information, and then when it finally comes down to, after the hearing's over, determining how to apply it, there's different standards based on whether the school has chosen the preponderance of the evidence standard or clear and convincing, and that affects how the ultimate decision might be made. So Susan, let me turn to you. What do we mean when we talk about preponderance, and how should facts be evaluated if the school is using a preponderance of the evidence standard?
So under the law, a preponderance of the evidence standard means that the evidence is proof that a particular fact or event more than likely occurred or did not occur. So it's this sort of amorphous, more likely than not. It's different than a beyond a reasonable doubt standard, which means that there's no plausible reason to believe otherwise. But this is more than likely to have occurred or not to have occurred, which can be ripe for discussion and disagreements, but that is the standard by which we're guided.
Yeah, absolutely, and I'm sure it would be. So let's turn to clear and convincing. What does that mean? And if a school uses a clear and convincing standard, how would they evaluate facts?
So by definition, clear and convincing standard is proof that a particular fact or event was highly and substantially more likely to be true than untrue, which again, learned scholars and legal professionals can disagree on this same fact. But once again, we need to be mindful of the distinction between it and beyond a reasonable doubt. So this is a lower, both clear and convincing and preponderance of the evidence are lower standards than beyond a reasonable doubt. And so in that respect, I apologize, Aaron.
No, not at all.
We should be questioning ourselves whether we believe that the fact is highly probable to be true. And that's, I think, incumbent upon the decision makers to keep checking themselves as they're assessing the information.
Sorry about that, Susan. I have as my wife will tell you, I have a tendency to interrupt people. She could attest to that. What I was actually going to say is, you know, and I know you guys know, just by way of example, I'm sure there are people listening to this thinking, how am I supposed to understand these two standards? They, to your point, Susan, sound amorphous and vague and very difficult. And if folks are feeling that way, you're right to feel that way. They are difficult to apply, and they are concepts of art, not concepts of science. I was involved in a rulemaking, not this rulemaking, but a different U.S. Department of Education rulemaking 2 or 3 years ago, where these two standards were very much at issue. So we had 17 negotiators around a table in Washington, D.C., trying to figure out which one of these standards to use in the context of this rule that the department was considering. And it was extraordinarily challenging. And we kept coming back to this idea that nobody really understood what the distinction was. I will say, though, the one thing that is clear, and I'll offer this up to those of you who may be first-time adjudicators or investigators, right, or anyone who's in part of this process and having to grapple with these standards. What is clear is that clear and convincing is a higher standard. Right. So when you talk about preponderance of the evidence, you know, how good you have to feel about something to believe that it's more likely than not. Well, that's sort of an internal decision. But what is absolutely unquestionable is that clear and convincing is intended to be the higher standard. So, and it's intended to require a greater level of proof. And, you know, whether that's 65% versus 50 or 75 versus 50 is always subject to debate. But if you've got a preponderance of the evidence standard, then you're sort of at that which way is it tilting type place. And if you've got a clear and convincing standard, then you know it's got to be more than just slightly tilting in one way or another. Right. And that's that I have found in my discussions with folks about these standards and understanding them, that at least understanding them relative to one another can be helpful, even if knowing exactly where they each fall independently can be a great challenge.
Yeah, and those are great points. And I'll just add one more thing. In my conversations with board members, questions come up, but how can they apply these standards without legal training? These are technical standards, and do you need kind of a background or rules of evidence to interpret this? And the answer is no. So first, I just want to point out that these are standards that juries use all the time, and juries are not made up of of legal professionals. But second, presumably as an adjudicator, a decision maker, you were chosen just based on your level of intelligence and expertise in your area, and just general common sense, good approach to kind of going about your job, and that will serve you extremely well in making these determinations. And they are absolutely not easy. But I think doing the work and kind of wrestling with this usually comes out to the right answer. So next, we'll talk about effective deliberations. And the first slide is really another question for you, Susan. One of the main issues or things for a decision maker to grapple with are issues of credibility. And how do they assess credibility? How do they weigh credibility? And especially in situations where it really is only one party, the complainant, and the other party, the respondent, that have direct knowledge of the facts, and the outcome may turn on which one you find more believable or not. How do you go about evaluating this and feeling confident in your decision?
And I know I sound like a broken record. It's not easy, and it is something that it's helpful to be guided by a couple of concepts as delineated on this slide. I think it's important for the decision maker to be asking themselves, does this seem believable? Does this make sense? Because ultimately, we do have to just kind of rely upon common sense in a lot of these situations. So being guided by this plausibility concept can be very helpful and ultimately speak to the credibility of the witnesses themselves. I think it's important to look at the person as they're testifying and the way in which they're conducting themselves to see if their demeanor is giving off any sort of symbols. You know, as Aaron started this whole thing off with, we're recording this during the COVID-19 pandemic, and I have had to do some investigations over Zoom, and you lose a certain level of that capability of being able to really see if someone's fidgeting or if someone seems to be looking at their advisor while they're testifying for support and guidance and hints. So it's completely appropriate for the decision makers to be taking all of that into account when deliberating on a decision. And finally, I think witness support and corroboration is while not everything, because we have already discussed in one of the prior training that the mere repetition of a story does not automatically make it true or relevant, but certainly witness statements and corroboration of either the complainant or the respondent's story is important for the deliberator to take into account. In addition to each of those, I think it's important for us to question, did this person have a reason to lie? That may seem obvious, especially for a respondent, but it's not always so cut and dry that the respondent would have a reason to lie or that a particular witness would have a reason to lie. So be critical and conscientious of that when going through the deliberations. Be cognizant also of any evidence or testimony about a history of similar behavior in the past. And this is something that's a little bit different in this process than in a piece of litigation in a courtroom where some of that evidence might not be admissible. Here it might very well be. And if you have that kind of information, presuming that you go through the same analysis of was that potentially a lie and was that truly vetted and determined? But if you do have that past record, that should be something you take into account, assuming all things are true and in your current deliberations as well. Now, I would say that none of the things that I just mentioned on their own are more important than the other. These are very factually intense determinations, and every piece of it needs to be analyzed as opposed to just one over the other. So while you should be guided by these principles, you should also be mindful of the overall picture and the overall evidence that came in.
Yeah, no, that's extremely helpful. I'll just clarify. I think that Susan, you were right to note at least the past record piece may be a little depending on if that evidence is allowed, and as we explained in a different module here, that the touchstone is if it's relevant or not. So there's a chance that this evidence might not be relevant and might not be able to be heard, but assuming it meets the relevant standard, then absolutely agree with everything Susan said. A couple more pieces. So I think it's one thing to evaluate a person's demeanor. It's another thing to evaluate expert testimony and medical records and things that someone with advanced training and potentially doing this kind of for a living for legal matters presents in this hearing. How does a board member or adjudicator with no medical or expert training evaluate these complex documents and testimony?
I think it's the job of the adjudicator to become as much of an expert as possible throughout the process by asking any question they have or feel that they need answered in order to really be able to understand the evidence being presented and offered by the expert. It will not be enough just for the deliberation group, if there is a group or an individual, to just say, well, if the expert says it's so, it must be so. No, they really need to push up their sleeves and ask as many clarifying questions as they need in order to appropriately weigh that information. We deal with this all the time in civil litigation, and it's a very important piece to ensure that juries really understand the information that's being presented. So if that means that the decision maker needs to slow down the process, ask the same question over and over until they understand it, ask for additional information potentially, whatever that decision maker needs in order to really understand and evaluate the information, it's incumbent upon them to do so.
And Scott, am I right? This rule, the department in the preamble, and maybe I'm thinking in the regulatory text, fairly specifically anticipates that experts may be a part of this new formal complaint process. I seem to recall that in the preamble, or again, maybe in the text of the regulation itself.
Yeah, no, I think you're absolutely right on that, and that's a change from the way that schools have previously conducted investigations. That experts are permitted, and they are allowed, and to the extent that the expert is providing a statement, as we'll explain in the hearings presentation, you have to have the expert actually come in to be subject to cross-examination for the adjudicator to rely on. That, assuming that's true, absolutely is something to be presented and considered by the decision maker. The other thing to keep in mind is an imbalance of resources potentially. So potentially one party has access and ability to hire experts in medical testimony, and the other party does not. So decision makers may very well be confronted with a situation where one well-financed party is able to present a very sophisticated, almost legal case, and the other party is not. And that is a challenge for the decision maker to be presented by a potentially one-sided, compelling case.
Yeah, and I would just dovetail off of that. It's possible that both sides will present their experts, and you'll have competing experts and competing opinions to take into account. And then it's even more important that the decision maker appreciates any nuances between the differing opinions and really digs into how two experts could reach different opinions in the same fact pattern.
Absolutely, and as you mentioned, Susan, this is a frequent in civil litigation, and this is something that lay people, non-legally trained people, are expected to do regularly in a court setting, and you might be asked to do it as an adjudicator in the Title IX setting. So let's fast forward, and let's assume that all the facts have been heard and evidence has been evaluated. And now it's kind of to get to brass tacks and determine what the final decision is ultimately going to be. Susan, what do you recommend in terms of trying to, assuming there's more than one person that's a decision maker, trying to kind of talk through each person's analysis and ultimately come to a consensus decision that you could put into a determination?
Yeah, and I think there is sort of a need to just respect the fact that if it's more than one person, chances are you are not automatically going to have consensus at the beginning. and that we really need to all be intentional in resisting the temptation to make a decision before having heard all the facts and before having evaluated all the facts. So that might mean pressing pause on the deliberations, even pressing pause on closing statements and taking a step back, looking at any questions that you as the adjudicator might have noted throughout the course of the hearing, and make sure you've answered or had all those questions answered for you before you get to the deliberation process. Because once you're in the deliberation process, you're not going to have that opportunity anymore. But once you do get in that room with your co-deliberators, it's really important that everyone be respectful and hear out other people's opinions about that, and not immediately pounce on one of your co-deliberators who just seemingly is not seeing these things the same way. Talk it through. Be rooted in facts, be rooted in testimony, be rooted in documentation, and steer clear of opinions or personal experiences. That being said, you can still go back to things like the person's demeanor, which is sort of inherently talking about your opinion of those behaviors or twitches or fidgets that you noticed in the person. And I think so long as everyone is listening with an ear towards really trying to remain polite and get to the bottom line, you might actually find that you are informed yourself by those observations that one of your co-deliberators had.
Boy, great advice, Susan. All great advice. Absolutely.
And I think with that great advice, that leads us to the last section of this presentation. So I think we're fast forwarding again, and you've taken all of Susan's great advice, and you've reached consensus on your decision. Susan, I'll pose this to you again. How do you, once you have done all the hard work, how do you put it into writing?
I think you should start by looking at the policy and make sure that you are adhering to your institution's policy when you do so, whether that's making sure that you make note of the clear and convincing standard versus preponderance of the evidence, whatever that is. Make sure you are guided by that specific policy when putting it together. I think it's also important that the tone of the determination reflects the gravity of the situation. So if you've made a determination that might be adverse to even the complainant, a respect for the allegation itself needs to be made clear, and made clear that we did not come to this decision lightly, or conversely, if it is in the complainant's favor and there's going to be discipline to the respondent, an appreciation that this might really impact the person's tenure at the school or educational survival at the school might ultimately need to be respected and called out in the deliberation, or excuse me, the determination itself. And I think then that tone will carry through and make clear that the outcome itself was taken very seriously and thoughtfully assessed before just reaching the determination that's contained in that writing.
Yeah, absolutely. And then kind of shifting to what happens after. So I think decision makers are keenly aware that a lot of Title IX disputes that go through a university process, college process, end up potentially in court or in front of the Office for Civil Rights at the Department of Ed. In terms of, with that kind of knowledge, what can a decision maker do to kind of make their determination as defensible as possible if ever reviewed or challenged by an agency or court?
Yeah, I think that's a really great point, because I think everyone who's in the position of having to draft a determination needs to be mindful of the fact that chances are other parties in the future are going to see this, and are they comfortable with their final written product with that in mind? it will most likely be exhibit 1 to any subsequent lawsuit. So be thinking in terms of, how is my writing, how is my work product going to present the institution in the best light, which is not to say, how do I draft it so that the institution will not be found liable? It's in fact, how am I going to represent the institution to show that the institution took this very seriously, as evidenced by the professional written product that we've put out. So I think in that respect, it's important to go back to some of those earlier slides about the format and content, steal directly from some of those key concepts, be guided by the written complaint or complaints, be guided by the language contained in the investigative report, be guided by the elements, whether that's within a written policy or the legal elements, and allow that to then form the basis of your written determination. And when in doubt, reach out to legal. Make sure that you are looping in your legal counsel so that the written determination really is as succinct and appropriate as it can possibly be, so that if this is ever appealed, or if it goes up to an administrative agency or civil litigation, it shows in the final written product.
Yeah, and I'll just add one thing to that piece about legal. Your conversations with your counsel are privileged, so you might have some ability to ask more questions, or kind of seek advice in a way that could be helpful to your product. I'm not saying not to do this, but just be aware, if you reach out to other people that don't have that privilege, those conversations, those emails could potentially be discoverable in the event of civil litigation. And what you don't want is to kind of take away the autonomy of the decision makers to make their decisions. So what I've seen, for example, is decision makers might send their findings for review by a supervisor or staff member. Just be careful that the staff member does not edit or take away or adjust it in a way that would undermine or potentially devalue the work of the decision makers. It really needs to be rooted. This is the decision of the decision makers here, and you don't want kind of any outside influence in that process. So not saying not to seek help, but just be aware that when you do, you want to make sure that help is compartmentalized in a way that doesn't affect the overall determination.
Scott, I'll put another finer point on that, or add a point anyway. And that is, if you're reaching out to counsel, just remember the role of counsel is to help you potentially to understand the information that you're sifting through, or to help you understand how you might present, that written document, right? I mean, counsel may have templates or thoughts about how to make it succinct, but I want to be really clear. Your legal counsel should not be substituting their judgment for your judgment. You're the adjudicator. So to the extent you're reaching out to them, it should not be for some sort of input that would impact your decision making. Not really. It should be for assistance potentially in crafting the document, or understanding how it should be written, or ensuring that the way you're crafting it is compliant with the policy, et cetera. The other thing I just want to remind, Scott mentioned this idea of potentially providing a draft to other persons within the organization. Certainly in certain circumstances that can be appropriate. But also keep in mind your confidentiality obligations, right? And every time you start to share your potential document with others, you're going to run into and be at tension with potentially some of your obligations regarding keeping things as confidential as possible. So I would just say, look hard at your policy, make sure on the confidentiality point that you're consulting with counsel, because you don't want to share this document with folks who shouldn't be seeing it any more than is absolutely necessary to get the job done. And also be mindful about the role counsel plays with regard to helping you craft and finalize the determination, and that your counsel isn't substituting their judgment, or you're not allowing them to or asking them to for your judgment, because you are the adjudicator. And with that, actually, I think that brings us to resources. So I'll go through this very quickly. If you, again, have made it through to the end of this presentation, thank you. We're glad that you did, and we hope you found it meaningful, and we hope you'll check out some of the other modules in the series. With regard to resources, every one of these modules, we point out that the Office of Civil Rights has a blog that they've created, and this is where they have indicated that they are going to provide guidance with regard to this rule on a go-forward basis. You can click on this if you have the actual slides available. You can click on that and there's a link and it'll take you to that page, or you can just Google Office Civil Rights blog. We also, whoops, there we go. We also have provided a comparison document some of you may be interested in, available on the same webpage where we've provided the slides, which shows the changes that the new rule made to the existing regulations. I know some folks, myself included, like to see that kind of view. It really gets you, helps you put a finer point, to use that phrase again, on what exactly was changed. And then I'll just offer, we offer at every one of these modules we've noted, we have a higher ed webinar series. It's free, it's on demand. One thing I haven't noted in every one of these sessions, but I will note here, is that these are all continuing legal education certified presentations. So if you're an attorney and you listen to the live version of this higher ed webinar series, you may be able to pick up CLE. I also will mention that we have a blog, Regucation. We're very happy for you to check that out. We talk about all kinds of things, lots of discussion about the CARES Act of late, and occasionally we make available free tools and resources, and we would be happy for you to get those. You can reach out to us and we can sign you up and we'll send you one if we have it available. If you're interested, there we go. If you're interested in the professional profiles, here at the end after we're done, there's an extended profile for Susan and Scott and myself, and then at the end, we have our disclaimer, just reminding you that we're not your attorneys. Thank you so much for tuning in. We hope again that you'll check out some of the other sessions as well. And wherever you are during this pandemic, most of all, we hope that you will be safe and be well. Thanks, everybody.